Good afternoon and welcome to this week's Lunch and Learn webinar. We run weekly webinars to provide advice and share knowledge on key topics. And joining me today is BizSmart Select member Kirsten Kluwer from Kluwer HR. And today's webinar, Kirsten will cover the fundamentals of the employee contract. Before we start the session, can I ask you to post any questions that you may have for Kirsten throughout the session, and she will do her best to answer them at the end. Thank you very much for joining us. Over to you.
Okay, hello everybody. Thank you for joining. First of all, start just by explaining who we are and a bit about what we do. I've got an HR consultancy firm. We're based in Overbury, which is just outside of Tewkesbury, and we offer HR advice and support to small, medium-sized businesses who have got who employ people to have all the issues that come along with that, but can't necessarily justify their own in-house HR professional. So we're there at the end of the phone or email to offer that support to them. Typically a client will get in touch. They might have some contracts which are out of date, some employment contracts, or they may have a member of staff who isn't performing quite as they should be, or they might have someone who's been off on long-term sick, and again they're not sure how they might go about managing that. So we're a bit rather like having your own little HR department, really. It's just that we don't sit in your office with you. So I'm thinking a lot of you will be thinking that we're here to tell you everything that should go into an employment contract, which isn't. I thought about doing that, and I thought actually that might be a bit boring. So I thought I gave some thought to the word fundamentals, and that's really what matters. What are the essentials to you as business owners and directors? We get calls every day from clients wanting to know how to approach and deal with various different issues with their employees. And often our starting point will be, so what does or doesn't it say in your employment contracts? So with that in mind, I thought the purposes of today will be about looking at what fundamentals should be in there. So we'll look at firstly what a contract of employment is and when one's actually formed, what a statement of particulars is and when you need to give that out to your employees, and then we'll go on and just look at what can happen if you don't do these things so that you can still go about making that informed choice. We'll also look at when you should issue these contracts and statement of employment, statement of particulars, and also what they need to include as a minimum. And then finally, and this is possibly the more interesting part, I suppose, is based on our experience, we're going to talk to you about what else you might consider putting in these contracts, so not just the basics. And I'll make reference to scenarios and cases where people have been caught out a bit, so that we can all learn from those hard lessons that of other people. So there'll be examples of cases where we've dealt with others, and some will be based on case law. So first of all then, what is an employment contract? There's a bit of a myth around this, that people think that if you haven't actually written down everything in a written document, that no contract of employment exists, and that's not actually the case. As soon as someone accepts a job offer from an employer, then that contract is formed, albeit verbally. So by default, all employees have an employment contract with their employer, regardless of whether it's written down anywhere. So a lot of people say, well, but I've heard it's the law, they have to have an employment contract. And this is that there is some legislation around employees needing to have employment contracts to an extent, but the part that they legally have to have is actually called the written statement of particulars, and that sets out the key terms and conditions of somebody's employment, and that's what should be given within 2 months of them starting work with you. And so we'll come back onto that document in a bit more detail in a bit, but just for the moment we'll just finish defining exactly what a contract is made up of then. So a contract of employment, these can be things that you've verbally agreed with your employee. They can also be things that have been made reference to an employee handbook, and they can also be things that might be written on the company notice board, or something written in an offer letter from you at the beginning of your relationship with the employee. They are also things that are required by law, so not necessarily written anywhere on any of your documentation, but it's legislation out there, such as national minimum wage, for example. And there also might be collective agreements set within your business, and if you're unless you're unionised, then that's less likely. You see more collective agreements in public sector. And then there's also implied terms. So these are things that are automatically part of a contract, even though they're not actually written down anywhere. And then finally, we've got custom and practice, which is things that have gone on, again, within that you've carried out, but you haven't necessarily documented anywhere, and you can say that they've become custom and practice. An example might be if you've continually, year after year, given everyone a particular amount, a particular pay rise, and then 1 year you stop, it could introduce some ambiguity as to whether or not that has become custom and practice. So that's an example of what might be custom and practice. So that's you can see hopefully why it's important to be so clear about what is contractual by having it written down somewhere, because if it isn't defined anywhere specifically, then there's all these places that we can pull from to make up what a contract of employment actually is. Okay. So I've mentioned already then these implied terms. So these are something in the contract. If there's nothing actually clearly agreed between you and the employer about a particular issue, it may be that it's already covered in an implied term. So, for example, you don't have to state that employees shouldn't steal from you for it to be a contractual agreement. So that's a good example of an implied term. It's an expectation. It's things that kind of almost go without saying. And there's an obligation on an employer to provide a safe, secure working environment. Again, that doesn't necessarily have to be written down anywhere. It's expected. There's a legal requirement for the right to give employees 5.6 weeks of paid holiday each year. And again, you can't go under that. So if you haven't got an employment contract, then the assumption would be that you would have that as a minimum. But there are plenty of employers that will go over and above what the statutory entitlement is. So it's always good, if you do go over and above it, to be specific in the contract, so that again, if it's ever called into question, there's no ambiguity around that. And it might be, another example is if you've got someone who drives for their job, that it would be an implied term that there's a requirement for them to have a driving license to do that. And then we touched on earlier the payment of a Christmas bonus, for example. If that is something that's regularly done, then it's arguably could become an implied term of your contract of employment. And then going back, then I just touched on earlier to custom and practice, and this is something that's been developed over a period of time or by arrangement, but has never been specifically agreed between the employer and the employee, and it's not written down anywhere. And there's no implied terms in legislation or anything, but it could be argued that it's become by default, it's become part of the terms and conditions of employment. So that's what you hear, that's what we mean when we say custom and practice. And that's something that does crop up quite a lot when people will ring up about a particular issue and they'll say, oh, but it's not in the contract. And we'll try and establish with the client then whether in actual fact it's something that they've been doing in practice over a long period of time anyway. Okay. So moving now on to then you as employers, your legal obligation part. This is the bit again that we've already touched on it. This is where employees with contracts that last for a month or more need to be given a written statement of particulars setting out the key terms and conditions of their employment, and this must be within the first 2 months of them starting work with you. So as we said, that contract is formed regardless of whether or not you've got it written anywhere, but the legal part that you need to remember is that you need to give your employees a written statement of particulars just to confirm the detail of that. And a lot of people say, well, what happens if we don't do that? What is the huge problem? We haven't given our employees a contract. We've been going for 10 years and they haven't got contracts of employment. And there are plenty of examples where you may well get away with this, but it is leaving you open to things being potentially, if anything did escalate to an employment tribunal, it's then you're leaving it then to the employment tribunal to determine what those terms and conditions are, and they're going to start looking back at custom and practice, implied terms, and things that you might not necessarily even have realised are in existence. So what can an employee do if they haven't got an employment a statement of particulars? Well, they can take out a grievance and ultimately then submit an employment tribunal claim for the lack of a statement of particulars, and then it would be down to the employment tribunal to decide what employment particulars what should have been awarded, and compensation can be from 2 to 4 weeks pay. And then also the other thing about it is that if an employee wins a case about another issue separate to any grievance they've got in relation to a lack of an employment statement of particulars, for example, if they claimed unfair dismissal, the tribunal may award some compensation on top of that if there's been a problem with the statement of particulars or lack of as well. So it just leaves you open a little bit to claims in areas where you may not have really appreciated they existed. So another common question we get then is, okay, you've convinced us that it's probably a good idea. We can appreciate that there's our legal obligation that we need to have this statement of particulars. We want a minimum. What's the minimum that should go in there? Well, the list here just shows you what you need to put in a statement of particulars as a minimum then. So we've obviously got the business name, the employee's name, their job title or a description of their work. And some people ask how much detail do you need to go into of what their job actually entails, and we always recommend not to go into too much detail. A job title will suffice, and to have a job description that's outside of the contract that defines in more detail what that role entails. And then if their role does evolve or grow or change over time, then you're not looking at changing a contract of employment to amend that. You're actually looking at amending a job description which is non-contractual. The other thing to go in there is their start date. That's important in case you ever do have to dismiss the employee for whatever reason. Could be redundancy, or so that you can work out notice periods that they're due from a statutory point of view. So keeping a record of their start date is really important. And also if any previous work that they've done within the company counts towards that start date. So it may be that they start in a particular role on one date, but they've got continuous employment prior to that from a different role, and that's very relevant because that's what counts when you work out their notice entitlements. Obviously their salary, details of their salary should go in there, their hours of work, whether or not they'll have to work Sundays or nights or overtime. Holiday entitlement is another one, whether or not that holiday includes public holidays. So whilst the statutory minimum is 5.6 weeks, you can specify as the employer whether those 5.6 weeks include public bank holidays, or whether you might require people to work on a bank holiday and you give that time off equivalent somewhere else. Where an employer will be working and whether they might have to relocate. So this is quite important if you envisage a business might have to move at some point in the future. Having a clause in there that gives you that flexibility can be quite useful. And also if an employee works in different places, where these will be, and the address. If it's a fixed term contract, a temporary role, then it's relevant in this document to specify how long that's likely to last, and the end date if it is a fixed term contract. Notice periods. So whilst there are statutory notice periods in existence that you need to get, an employer needs to give an employee, there's nothing defined in law as to what the employee needs to give the employer. So it's always a good idea to be clear about what notice periods you want them to give, and you may go over and above the statutory notice period that you give to your employees. Collective agreements, as I said earlier, this is more around where you've got a unionised environment, but if you had got any collective agreements, then you would make reference to those in this statement of particulars. And if you haven't, it's not a bad thing just to state that there are no collective agreements in place. Reference to your pension provisions are also should also go in this document. You don't have to go into huge amounts of detail. You can then signpost them in another direction to get the detail, but the sort of bare essentials of your pension arrangement should go in there. And also where an employee should go if they've got a grievance. Now again, you don't have to go into great reams of detail about your grievance procedure, but you should be signposting the employees to where they should go. And then the same applies for your disciplinary procedures as well. You need to be able to signpost them in the direction that you need to go in. Okay. So what doesn't a statement of particulars need to include? Well, as we say, it doesn't. It's good to have some essentials around your sick pay. What you pay them if they're off sick, particularly if you go over and above the statutory sick pay, but you don't, and any sort of key procedures that you've got in place. So for example, if you require them to phone in before a certain time on their first day of sickness, then that might go into your contract, but the full detail around a sick pay would be more likely to go into the employee handbook, and therefore it's not contractual. So if you ever made amendments to it, then it's much more straightforward. You wouldn't be consulting with staff on changing their terms and conditions of employment necessarily. And the same with your disciplinary and dismissal procedures and your grievance procedures then. And so, as I promised at the start, we just look at other clauses that you might consider, or other bits of detail you might consider putting into your employment contract. And this is by no means exhaustive, and it's very bespoke to your individual companies as to what you might do here. But some examples of where you might then add a bit more detail is going back to the sickness. You may specify in the contract who they should contact when they're off sick, and what medium they should use to make that contact. So if you're quite clear that you wouldn't want an employee just texting in, then it's not a bad idea to put that into the contract, and it just removes any confusion and makes it absolutely black and white that that's what you require them to do. And it also removes arguments that you're treating employees differently and potential there for discrimination claims, because you can argue that it's actually there in the contract and that everyone's required to do that. And if then you do get issues with people not following those procedures, then you can act much more quickly when issues do arise. And also it can make people think a bit more carefully before they take a day off sick. Another thing that we would recommend putting into an employment contract, which isn't sort of stated as essential, but we would recommend it, is a clause around have a conflict of interest. And we unfortunately had a client who didn't do this, or they didn't have an employment contract for their employee. So therefore there was no conflict of interest clause to refer to. And when this employee went off and set up his own business in the same industry area, in the same geographical location, it was quite a grey one to pull out and actually define where he had breached his contract, because we were left with implied terms as to what's reasonable. So it's good to be quite specific about what you as a company would regard as a conflict of interest. And that one did actually go to an employment tribunal, so it's one we're quite hot on at the moment, actually. Another one to think about, being quite clear about in the contract, is particularly if you have workers in safety critical roles where drug or alcohol use would in particular be a problem, to have some clarity in the contract around what drug and alcohol testing you do and how you do that. Again, the detail can go into an employee handbook, but the fact that you withhold the right to do drug and alcohol testing should go into the contracts. And again, it just removes that it would become a breach of contract from the employee's point of view if they then refuse to give you a test, and makes managing situations around that much easier. Sick pay is another one that's important to be clear on, and I would suggest in the contract. We've got lots of, when we go into companies and do their initial when they engage us, we go in and we'll do a health check on their HR procedures, and sick pay is something we look at. And lots of people say, oh well, our contracts state that we just pay SSP, but actually in reality we rarely deduct the first 3 waiting days, or we'll always pay, or we've got someone who's been off for 6 months and they're still on full pay. Whilst that's nice and it suggests that you're a caring employer in many ways, you are setting a precedent there that and potentially a custom practice. So if paying more than the statutory sick pay is something that you want to think about doing, we would suggest that you think about exactly what that might be, and that you do implement the cut-off at the point that you choose, so that you're not then open to people saying, well, you did that with them and you didn't do that with us. Again, it's that thing around potential discrimination claims. And then bonuses as well, that's another one that we would, if you do a regular bonus, then you could put something in the contract around that. Or if you don't do regular bonuses, but you have been known to pay your bonus 1 year and not the next, then we would recommend a clause in the contract which states that they're discretionary, and just because you pay a bonus 1 year, it doesn't necessarily mean you're going to do that the following year. And again, it just gives you that extra bit of protection. If people start thinking that they've built up a right to something, then you've got that in the contract to refer to. Another thing to think about is restrictive covenants. Now they are quite difficult to enforce, but we always think it's still worth having something in there. It can act as a deterrent. For example, if you were a hairdressing business and you didn't want, it's not just when someone's left the business, but also when they're in the business, it's about activities that you would or wouldn't be happy with them carrying out that might conflict again with what you're doing. So you might state that if a person, a stylist, left the salon, that they don't go and work or set up a business in competition with you within X amount of miles around you. And you also might state that even when they are employed with you, that they may not take business from your company and do that in their own time. So those are just some ideas, and there are lots and lots more of ways that we would bespoke a contract to make it work for individual businesses and offer that protection and flexibility as well. But those are some ideas for you to think about. So I hope you found that useful. All that remains for me is just to say thank you for listening, and if you've got any questions, please feel free to ask them.
Okay. Excuse me. Thank you so much for that. That was very interesting. Thank you very much. We've got a number of questions come through, so I'll read them out to you. Is that okay? The first one is, how often should we renew our contracts?
Okay, yeah, it's a good question. We as with our retained clients, we're constantly reviewing them. We'll do a sort of overhaul every 6 months with our clients, just to check that. But we'll keep an eye on case law and also changes in legislation and do reviews then. And then, so that's every 6 months. It all depends on what changes you've got in legislation going on at the time and whether or not they impact on contracts of employment. But I would be looking at a minimum of looking at them every 12 months, really, just as a refresh and almost doing a health check on them.
Okay, thank you. Next question. Do we need to have an employee's handbook to go alongside their contracts?
Yes, I think I've touched a little bit on employee handbooks in what I've talked about today. I think what we say is to put the fundamentals should go into your contract, your employment contract, the bits that you're absolutely clear on that you wouldn't want to change, and then the detail that goes around that to then put into the employee handbook. So if you do want to make tweaks and changes to the way the procedures and policies, then you're not effectively consulting with your staff every time you make those changes if it's just in the employee handbook. But of course, if you want to change a clause in a contract, then that you are changing terms and conditions of employment, and that means going through a whole consultation process, which, depending on the number of employees affected, can be quite a process. So we say you want the contracts to protect the company as much as possible, but then it's getting the balance between what you put in the contract and how much you put in the employee handbook. But in answer to the question, yes, we would advise having that employee handbook alongside your contract.
Okay, thank you. Following on from that, Roger's asked if the contract has terms that are different to the staff handbook, which one rules?
As a rule, the contract would prevail. Yes, but then you could, if there was custom and practice, it's not black and white, and it would all depend on individual situations. But I'd say, as a rule, the contract would prevail. But if we had a client ringing us and asking that question in relation to a specific incident, we would just be wanting to get a feel for what's actually gone on in practice, to check that there wasn't anything outside of that would sway it in the other direction.
Okay, thank you. Another question. Is there a role for a standard commercial or employment contract, for example, from an organisation like the FSB?
Okay. Yes. So you can get. I'm assuming you're referring to the contracts that you can buy or download quite readily online. Yes, there is a role from them. They'll do what they say on the tin. They are template contracts, but they won't be bespoke to your individual business. There are clauses, as we've talked about today, that can add that give you that added protection. So yes, there's nothing wrong with those, but they won't be working for you as well as something that's been designed specifically for your business might do.
Okay, thank you. Another question, how do I establish clear boundaries between company and private life? For example, Facebook for business use or LinkedIn use at home, at work and at home? Yeah,
that's a good question. We recommend being clear about, first of all, establishing what you as a business, what's the risk to you as a business of people using Facebook, and working out what you can stand and what you can't, and then having the clear boundaries within your employee handbook and making it clear and being clear to your employees what those boundaries are, so that people, if you do ever have to address somebody, that you're referring to your policies and procedures, and that their expectations are managed prior to you having to pick it up with them as well.
Okay, thank you. Another question we've had, do employees have to declare any abilities, disabilities, gender or equality issues, i.e. if they have an illness that might affect their ability to perform their duties? Should this be built into their contract, and should they have this proven by a doctor or professional?
So when you recruit somebody, it's okay to ask at the interview stage whether they've got any disabilities that need to be taken into account so in case you need to make any reasonable adjustments as part of your recruitment process. So it may be something as simple as if they're a wheelchair user, then you need to know that so that you don't put them on the first or second floor when you're carrying out the interview. Or if someone's got impaired hearing, whether there's some equipment that they need to use. And that would follow right through to the point of offer and recruitment. So it's fine to ask employees that question if they have you got a disability that we should be aware of, so that then you're in a position to make those reasonable adjustments to put them on a level playing field with their colleagues to be able to perform their role. But if they choose not to share that information with you, that's to an extent up to them. But it's almost putting them on a back foot, because it doesn't. If there are reasonable adjustments that they need making, then you can't be expected to know what those are without having been given the information. There is also an obligation on them to tell you if they would be putting other people in danger as a result of not giving information. I hope that answers it for you.
Okay, thank you very much. Another question. Restrictive covenants, they are very difficult to A, prove they are broken, and B, enforce. Why do companies still try to include terms that are clearly unfair?
Okay, well, first of all, yes, they are difficult to enforce. That's absolutely right, Roger. Companies will still include restrictive covenants because, as I said earlier, actually, I think we just alluded to it a little bit there, that whilst they're tricky to enforce, you may as well put them in there because they may act as a deterrent, and some companies have been known to enforce them and successfully. Your point about why they put things in there that are clearly unfair, I would suggest it's that they haven't been advised properly before they put them in there, but a court will not enforce anything that's mildly unfair anyway, so they're not worth the paper they're written on if they are deemed to be unfair. They would be unenforceable.
Okay, thank you so much. I think that was the last question that we've received. I will email Kirsten's details out to everybody, so if you have any more questions, I'm sure she will answer them via email, or you can contact her direct. Thank you all for joining us, and thank you so much again, Kirsten, for hosting today's webinar. I hope you found it useful. As you know, we host webinars every week, so I hope you can join us next Tuesday as well. Just thank you again, and hope you all have a great afternoon.